So one of the most common questions that I get these days from clients is, in Reg D, I'm raising some money. What's the difference between 506B and 506C? It's a very, very common question. So I'm going to kind of go over what the differences are between. Let me share my screen. Okay, so anytime we're talking about 506B and 506C, these are sort of the private placement securities exemptions that are very common, which are found under the Code of Federal Regulations, were considered Reg D. 506A says that offers and sales of securities by an issuer, which is the company that issues common stock, units, whatever the security is, that satisfies the conditions in 506B or C, deemed not involving a public offering within the meaning of 482 of the Act. So basically, if you conform to 506B or 506C, you don't have to register your stock with the SEC as if it was a public offering, which is not easy. It's expensive. It takes a lot of time. So people rely on these private offering exemptions when they're raising capital. So Rule 506B is probably the most common used to privately raise capital. Somewhere between 80 and 95% of private capital is raised under 506B. There's no dollar limit on the amount of capital you can raise. You can bring in basically an unlimited amount of money. You do have to have a pre-existing substantial business relationship with your investors. So you can't generally solicit or advertise. You can't put it on Facebook. You can't put it on Instagram. You can't go to networking groups where you don't know people and start telling them about your offering. You can have an unlimited number of what are considered accredited investors. These are people who meet the definition under Rule 501. There's about 14 definitions. The most common is over $1 million in net worth, or over $200,000 in salary for an individual, $300,000 for a couple. There's a number of other exemptions that qualify for accredited. I have separate videos that go over those, but you can look that up online, the definition of accredited investor. But you have to make sure you look at the current version because it was changed within the last few years and expanded. You can also have up to 35 non-accredited people who don't meet that definition. Maybe they don't make over $200,000 a year, but they make a decent living. They still have to be sophisticated, which there's no set test. But the way the SEC talks about it is they have knowledge and experience in financial and business matters, so they can evaluate the risks of an investment. Or basically the issuer, the company issuing stock, reasonably believes that they come within the definition of sophisticated. So they need to have some financial and investment experience. And basically, if they can potentially lose all of their money, it's not going to severely impact them. Now, there are disclosure requirements under 502B, which is a part of Reg D for a 506B offering. There's financial and non-financial information has to be provided in an offering memorandum or private placement memorandum. And this is basically about the company, the offering, the financials of the company. And also you have to provide all prior materials you gave to your prior investors and give your investors a chance to ask questions and request additional information to evaluate your offering. You need to give them enough time to look into the merits of the offering before they invest. Now, you also have to advise them that these are restricted securities and they can't turn around and resell them unless there's an exemption available. If they're non-accredited, you are required to provide a PPM prior to them investing. Now, it's pretty common that any larger offering, you're going to have a PPM in place anyways, because a lot of people involved are going to, essentially expect that you have one, so that they can look over written materials about your business plan and the risks of the offering and investing. And it's a good, provides backup protection for you in case an investor sues you down the road and says, I lost money because you didn't disclose to me X, Y, and Z risk that was involved, and you've got a PPM, you can say, look, I gave you a PPM, here it is, here's all the risks, and I already disclosed all that to you, so you were fully aware of the risks when you went in. Rule 507 also says that you cannot have bad actors involved in your offering. So if somebody who has been sanctioned or basically gotten in trouble with the SEC or a state securities agency in the past, they might be disqualified from being an executive officer, manager in your offering, and you can lose an exemption if, in some cases, if they stay in. So you may have to preclude them from being involved. So you have to make sure that no one on your management team fits that definition of bad actor. Now let's look at Rule 506C. These are less common, but they're getting to be more common these days. There's also no dollar limit. You can raise an unlimited amount of capital, have an unlimited number of accredited investors, can't have any unaccredited. Everybody's got to be accredited. And you have to take steps to verify that they're accredited. So in 506B, you can just have them check a box and sign, basically saying, yes, I'm accredited. 506C, you have to take steps to verify in writing, typically, like a letter from their CPA that verifies that they're accredited, or looking at their bank statements and tax returns. So you have to take additional steps, otherwise you can lose this exemption. So you have to make sure that at least you've taken reasonable steps to verify. If it turns out they're not accredited and you did take reasonable steps, you're still protected under a safe harbor, but you still have to show that you took those steps. General solicitation and advertising is allowed. So you can post this online on social media. You can go out to networking groups where you don't know anybody and tell them about this offering. You do need to make sure they're accredited before they invest. But you can go out and go anywhere and tell people about your offering, but you have to make sure that it's not false or misleading, because you still can be prosecuted under the anti-fraud provisions of securities offerings. There are disclosure requirements under 502D for this type of offering. They're not as stringent. You have to advise that these are restricted and you can't resell the securities. PPM is not technically required because it's all accredited investors. However, the majority of them that I see and that I'm involved in, there is a PPM because it's a best practice, provides the best protection. And if you're publicly posting this somewhere, most portals or anyone that you're involved with is going to require that you have a decent PPM that discloses the risks because it also covers them. Rule 507 also comes into play. No one on your management team can have any bad actor disqualification. So essentially, Rule 506B and C both have unlimited amount of capital, unlimited number of accredited investors. Under B, you can have unaccredited investors, but you have to have a pre-existing relationship. You can't solicit or advertise. Under C, you can solicit or advertise, but you're limited to only accredited investors, and you have to take those extra steps to verify that they are accredited. So there's additional time and money involved in doing that. Under B and C both, you have to file a Form D, which notifies the SEC that you've raised capital under either 506B or C. You have to check the right box. You also have to file blue sky notice filings in each state where your investors are located. And this has to be within 15 days of the first sale of a security. And with its blue sky, it's basically first days of sale of a security in that state to an investor in that state. Some people will tell you that, oh, there's no blue sky filing required under Reg D. That's not true. There's a federal preemption for Reg D offerings, so that in each state you don't have to qualify or register the stock. However, it's very clear under the law that you still have to provide the notice filings, the blue sky notice filings in each state where your investors are located. So make sure you do that within 15 days of the first sale of a security. Otherwise, there can be some consequences to that if you don't take care of that right away. Hopefully this provides a little bit more information and If you have further questions, you can contact us. I'm also going to have some other videos that talk about some of the specifics of offerings, accredited investors. So look for those to come.